Hello, I'm Adam Kielich of the Kielich Law Firm in Bedford, Texas, and today's video is about contingency fee agreements. A contingency fee agreement is a fee agreement between an attorney and client in which the attorney agrees to be paid out of a percentage of whatever the attorney is able to recover for the client, rather than being paid out of pocket by the client on an hourly basis or a fixed fee or retainer or some other type of fee agreement where the client is writing a check to pay for the attorney's services. Under a contingency fee agreement, the attorney is only paid if the attorney is able to recover something for the client, and the attorney is going to be paid a percentage that's fixed within the agreement, no matter how large or how small the amount of recovery happens to be. Sometimes in contingency fee agreements, there will be a scale so that the attorney's percentage increases depending upon how quickly the case settles or if it goes to trial. Although a contingency fee agreement may have a flat percentage regardless of when it settles or if it goes to trial. These types of fee agreements are often beneficial for clients who may not have the money to be able to pay out of pocket for the attorney. And this can be especially true when the case is very large or very complex or it takes a very long time. And this is common for cases that are taken on contingency by lawyers, particularly within employment law or personal injury. In these types of cases, the attorney fees on an hourly basis may be in the tens of thousands of dollars or even into the hundreds of thousands of dollars in attorney fees, and most people don't have that kind of money to hand over to an attorney. A contingency fee agreement can also be a good deal for the attorney because it means the attorney does not have to make financial decisions about what the client can pay. Instead, the attorney can look at the value of the claims and determine whether the claim is valuable not only to the client, but to the attorney as well. This avoids a situation where the attorney and the client are both on the same side of the lawsuit, but have something of an adversarial nature itself if the attorney is tracking down the client to make sure that the client is paying a bill or that the client doesn't have the money to pay the bill, what the attorney is going to do to either stay in the case and get paid or withdraw and sort of leave the client hanging out there. Under a contingency fee agreement, both parties are united on the same front towards getting that recovery. Under that contingency fee agreement, the attorney takes on the risk of the claim evaluation, again, making sure that the claim is worth something of value to both the client and ultimately the attorney so he or she can get paid. And that carries along with it the risk that the attorney may do that tens of thousands or hundreds of thousands of dollars of work and not get paid. On the other hand, the client avoids a significant financial risk by not paying out of pocket for the attorney. So in these contingency fee agreements, the attorney is really the one who takes on the bulk of the risk in assessing the claims and prosecuting it at the risk of not getting paid for any of that work. Whereas if the client pays out of pocket for the attorney, there's always a chance that the case goes to trial, the client loses, and the client walks away. Well, if the client is paid out of pocket, the client is not only out whatever the value of the claim might have been, but also what was paid to the attorney. Under a contingency fee agreement, if the case loses and nothing is recovered, the client walks away with that loss, sure, but the client doesn't also have that huge attorney bill. So as a result, the attorney is really taking on quite a bit of risk in these cases. And so when contingency fee agreements have this large percentage of the recovery, often somewhere between 25 to 40% of the total recovery, part of the reason for that is because the attorney takes on so much risk in assessing the claim and prosecuting it without being paid anything up front. It's easy to take those kind of cases where it's probable or almost certain that the client is going to receive some sort of meaningful compensation in the case. And if that's the case, maybe the attorney is going to ask for a smaller percentage. But in employment cases where they're very difficult, very complex cases, often the contingency fee percent is going to be very high to account for the amount of risk the attorney is taking on, and for the fact that in many of these cases, the attorney doesn't recover because for whatever reason the other claims have failed. So although there are some benefits to both sides, each side also needs to think about the risk involved and whether it's valuable for both the attorney and the client to take on this kind of fee agreement. Given a particular case, it may make more sense for the client to pay out of pocket to the attorney rather than accepting that contingency fee agreement. But as with everything in the law and clients and their claims, the individual situation or the individual claims that a client has will govern what kind of fee agreement really makes the most sense.